What happens to the house and property when a common law couple separates? For married couples, Ontario law tries to make sure that each spouse's net worth increases by the same amount during the marriage. It does not do this for common law spouses. For common law spouses in Ontario, the default position is that each spouse gets to keep what is in their name. So if a house is in just one spouse's name, the presumption is that it belongs just to that spouse. The same goes for vehicles, RRSPs, and bank accounts. For things that don't have an ownership document, like a couch or television, the person who paid for it keeps it. It is important to note that there are some legal arguments that common law spouses can make to try to assert an ownership interest in something that's not in their name, and they are all based on principles of fairness. An example of a situation where this kind of argument might work would be where, even though a house is only in one spouse's name, the other spouse has contributed to the property in a significant way. For example, by doing renovations and maintenance or paying for the down payment or mortgage. The spouse who is not on title to the house could argue that it is not fair for the other spouse to be the only one who benefits from their efforts. These legal arguments are quite complicated. Ideally, you want to avoid ever getting into this kind of situation in the first place. You can do that by making sure that legal title to an asset accurately reflects who contributed to the asset. Sometimes people put title in only one spouse's name for tax or other reasons, but this can be risky and can cause major problems in the event of a separation. You can also enter into a cohabitation agreement, which is a contract that sets out how you will deal with property. This ensures that both spouses are on the same page when it comes to who will get to keep what in the event of a separation. I've just described the law in Ontario, but across Canada, provinces deal with property division between common law spouses in very different ways. Alberta and Quebec deal with it in a way that is similar to Ontario. In other words, title governs for common law spouses unless you can make a successful legal argument otherwise. BC and Saskatchewan, on the other hand, treat common law spouses the same as married spouses when it comes to property division. The increase in the value of assets during the relationship is equally shared unless an exception applies. In Nova Scotia, common law couples can opt into the same property regime that applies to legally married spouses by filing a form with the government. In Manitoba, common law spouses can also opt into the same property regime that applies to legally married spouses. However, even if they don't do that, once the couple has lived together for 3 years, all the major property laws that would apply to legally married spouses also apply to them. Another thing to remember is that each province has its own definition as to what constitutes a common law relationship. In some, this area of family law is far from uniform across the country and can be quite complicated.